Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As in the series of Jurisprudence 2, I have discussed certain important questions relating to the jurisprudence. Today in this video, I am going to discuss with the one more important question relating to the ownership. What is ownership? And what are the characteristics as well as types of ownership? This is my question. If we talk about the ownership implies the bunch of right over the thing owned. And this bunch of right consists of the various interests, powers, liberties, immunities that vest in the owner with regard to the thing owned. And these rights are recognized and protected by the law. However, law can impose certain limitations on these rights in the public interest and to regulate the general transactions concerning the ownership. If we talk about the definition of ownership that has been given by certain jurists. First definition is given by Professor Austin. According to Professor Austin, ownership is a right prevailing against the world over a determinate thing, indefinite in the point of user, unrestricted in the point of disposition, and unlimited in the point of duration. Second definition that is given by Professor Olen. According to Professor Olen, ownership implies the plenary control over the object. However, the owner has three rights over the object owned. That is namely right of possession, right of enjoyment, and right of disposition. And the third definition that is given by Professor Salmon. According to Professor Salmon, ownership is, in its most comprehensive significance denotes the relationship between a person and the right vested in him. A man owns in all cases, that is a right. And ownership extends to all kinds of rights, liberties, powers, and immunities. Ownership is relationship between the person and a thing. Next definition that is given by Professor Pollock. According to Professor Pollock, ownership is the entity of power of use and disposal allowed by the law. On the basis of these above definitions, we can define the certain characteristics of the ownership. First characteristics of the ownership, that is the right of possession. Title of ownership implies the right of possession in the person in whom the title is vested. So the person must possess the thing he owned and he should have legal right to the possession. For example, if A gives his house to B on lease and his taxi on hire to C, then A is not in a position to acquire a immediate possession of the thing owned. Still the ownership will vest in A. Hence, a owner does not lose his ownership even if he does not have the right to possess the thing at his will. And the second essential characteristic of the ownership, that is right to enjoy. Ownership gives the owner right to enjoy the thing as he desires. But this right is not absolute right. And law imposes certain limitations on this right also. And use his property in such a way not to injure the right of the other persons. And right to use and enjoy the property may be curtailed by the agreement between the parties. And the third characteristic of the ownership, that is power to dispose of. Power of the disposition includes the power of alienation, alteration, destruction of the property owned. The ownership that is unlimited in the point of duration. Ownership is indeterminate ownership that exists for the thing owned. An ownership right is a possession and can't be subject to duration. Ownership right can be perpetual and cannot be subject to duration. And the death of the owner devolves his right that is given by the law. This means on his death, ownership devolves upon his legal right. Next characteristic of the ownership, that is residuary characters. Owner of a thing may bestowed several rights relating to the thing on the different person, but still he continue to be owner because the residuary rights rest in the owner exclusively. If we talk about the classification of the ownership, that can be classified under the certain heads. First classification, that may be on the basis of corporeal and incorporeal. Corporeal ownership means ownership of the thing, that is material object, that may be house, land, car, etc. While incorporeal ownership means on the ownership of the right, such as shares in the company, patent, copyright, etc. And the next type of classification, that may be on the basis of trust and beneficiary ownership. According to Salmon, trust ownership is that which is owned by the two persons at the same time. and one of them is under the obligation to use his ownership for the benefit of the other, while the former is called trustee and the his ownership is the trust ownership. For example, if A takes property in trust for the B, then A is trustee of the property and B is the beneficiary. Hence, A is having the ownership and B is enjoying the beneficial ownership. Next type of classification of the ownership, that may be sole ownership or the co-ownership. In the ownership, if the ownership vests in the single person, that is called sole ownership. If the ownership vests in two or more persons, that is called co-ownership. For example, partnership, trust, the examples of co-ownership. Next type of classification of the ownership, that may be vested ownership or the contingent ownership. When the ownership gives the present right to the immediate possession of the property, it's called vested ownership, while an estate which gives a present right of the future possession of the property, that is called vested interest. While on the other hand, contingent means which depends upon the happening of the certain event. According to Salmon, ownership is either vested ownership or the contingent ownership. This was all about the ownership. That is also one of the most important questions for the examination point of view. And if you have any doubt, then you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.